So whenever you would like to start.
Yeah, I guess we're gonna call this meeting to order the KWWA 40. It is 6:04. We do roll call.
President Whitman. Except for now, you say he's gonna be late. Okay,
Did you get your public comment, Judy?
yes, I did. Thank you. Vice President Parker. Present. Okay, Director Brown. Present. Director Wager.
Present.
Director Croft.
I'm here.
Okay. Here's your roll call.
All right. I guess we'll move on down now to the consent items, approval of the agenda. So at this time, I guess, does anybody have anything to add? Any changes to the approval of the agenda?
I did not.
No changes?
So
So
You need to
all in
entertain-
favor, say aye. for the
you need to
approval.
entertain motion.
Entertain the motion.
I'll make a motion to approve the amendments, the agenda.
Thank you. Second. All in favor, say aye.
I
Aye.
Okay.
Good. Moving on now to the approval of the minutes for the June 9th, 2024 monthly meeting. Is there any changes or additions to that that anybody would like to add?
On the financial report, I noticed after we went home that there was a discrepancy on it.
Okay,
So I would like to relook at that and relook at tonight's. Since we haven't had a chance to look at that,
okay,
I think there will be a change on last night's.
okay.
Okay.
Okay,
Is there any other changes or additions that we'd like to add?
One more point here.
okay, okay. So you need to entertain the motion.
I'd like to entertain a motion to approve the minutes for the June 9th meeting with the change of the financial report to be reviewed.
I'll make a motion to approve.
Second. All right. Can I get all in favor, say aye.
Aye.
All opposed, same sign.
Okay.
Motion passed. Now we'll be to the financial report, year-to-date profit loss. You want to put them up on that? No?
I would like to table it so I can go home and look at it, since I think there's a discrepancy on last month's. I need to see if it rolled into this month. And since we just got them, I have not had a chance to review them.
Where do you think the discrepancy is?
Right now I'm looking at. My core and main water, the numbers are off.
I'm sorry, so the exception.
The core and main water. For 8,819 from last month, I believe those numbers are off. I
Water
just wanna
repair,
double check.
is that what you're looking at?
I think we're under, I think we didn't get charged, yeah, I think there's not,
Well, there was a big credit there.
was there?
Yeah, Paul sent back a bunch of, so
Okay,
that could account for that.
okay,
But I'll confirm that with Paul and just so you guys know, Paul did just text me, he's gonna be in an emergency and he's not gonna be here tonight.
okay,
So I just now got it.
okay,
Sorry.
alright. So, but I would like to look this over, I haven't had a chance, so I can't.
I want to speak to something on your report tonight. During the course of the audit, we found out that backhoe that we sold in auction was actually a third owned by the water. It was under the water enterprise when the town had the water. When the water was transferred to Kiowa Water and Wastewater Authority, everything that was in the water and wastewater enterprise accounts or under their budget transferred to the water authority. Meaning when we sold that backhoe, you owned a third of that asset. So the town has cut a check for $4,333 to the water authority.
Thank you.
You're welcome.
Herb? Is there anything else on the your day of profit and loss report other than table? Anybody have anything to say?
Okay, I'd like to speak about some of the financial report. I'd like to, again, address the latest White Bear invoice, which is rather unbelievable. This one has been worse than any of the other we had. Again, I'm appalled by the June 24th invoice from White Bear that is unbelievable amount of $14,164.61 for 1 month. As a recap, I'm gonna go through all the last 6 months and just tell you how much money we've already spent with White Bear. In January, we paid $28.95.63. February was $1,075.23. March was $8,937.85. April was $10,205.78. May was $7,288.24. And June is $14,164.61 for a grand total for just 6 months, $44,567.34. Our annual budget is only $12,000 per year. And we've already spent $44,567.34 for the first 6 months. I'm just asking the board, is anybody else concerned about this like I am? That we are spending this kind of money for White Bear and we're not really getting, I don't believe we're getting the service we deserve. These invoices are open-ended and out of control with no accountability by White Bear for the expenses being billed. After discussing with White Bear the outrageous April 30th invoice of $10,205.87 at our May 14th meeting, on June 3rd, I emailed Scott Goodson a copy of the April invoice, upon which I noted my questions and concerns about certain billed expenses, along with a list of general questions about the White Bear billing and invoicing practices of the April invoice, upon which I noted my questions and concerns about certain billed items, along with a list of general questions about White Bear billing and invoicing practices. On June 4th, I received an email response from George Rowley, not Scott, addressing only my general questions about how the expenses were billed, but nothing about the specific expenses that I was questioning, and he asserted that every expensed item in the bill was a valid and legitimate justified expense with no room for discussion or adjustments to the invoices. And then they had the gall to bill KWWA for reviewing that April invoice, $96. Most of the items being discussed by 2 or 3 or more White Bear attorneys, employees have been repeatedly rehashed over several months with no actual results. And many of the issues being rehashed for multiple days over multiple months concern items and issues that do not even need to be dealt with now or possibly ever. Why are we paying Scott Goodstein or George Rowley to attend our KWWA meetings by Zoom or in person? And then when we ask questions, he doesn't answer the question. And he always gives an excuse that, well, he's not sure of the answer, but he will have to consult with his colleagues and get back to us. All of which will be billed to KWWA every 6 minutes. They bill on 1/10 of an hour every 6 minutes. If the White Bear attorneys are not experienced or qualified enough to answer basic, simple questions on the spot, then why are they our legal counsel? Or if they are not qualified to handle any and all of the legal issues, general litigation, document preparation, basic proofing, in the best interest of KWWA and the citizens of Kiowa, then why should they still be employed by KWWA? KWWA has become a cash cow for White Bear. With these escalating out of control White Bear invoices and the rehashing of items and issues without any results, KWWA needs to find another legal counsel that will provide honest, reliable, and quality legal services for a reasonable price. KWWA cannot afford White Bear any longer.
Scott, are you on Zoom?
Yes, I am.
Would you like to address any of these concerns?
Um, well, for one thing, I guess I would say it's very common for law firms to bill um at a rate of 6 minutes. Um, one of the reasons why I attend these meetings is because I am specifically asked by the board to attend them. Um, uh, Director Brown, like I said at the previous meeting, if you have any questions about any invoicing items, you're welcome to reach out to us and we can go through those items. To the best of my knowledge, you did not do that between now and the previous board meeting. I can't really say anything more than that. I'm here to provide legal counsel because that's what we've been hired for. And if, it's, I would prefer to give you an accurate answer when you ask me questions, especially if they are spontaneous, rather than just giving you, vagaries. That's why I be sure to tell the board, I'll take your question and I will consult my colleagues and make sure that we are coming back to you with the most accurate answer.
But then why are we being billed for your responses to questions about an invoice? That doesn't sound right to be billed again because we asked a question.
Director Brown, I don't know the specific item that you're referring to. If you reach out to us to discuss these items rather than doing this at this meeting, we'd be happy to go over that. And in the event that, there's something that needs to be addressed, we're happy to do it. We are truly happy to discuss these matters with you. You just need to contact us and, bring forth the questions about the items that you have.
That's what I
don't
did.
know what item you're talking about right now.
That's what I did with that April invoice. I took the time to go over the invoice in great detail and note all my questions on the invoice, and I emailed it to you. And then all I got back from that was that George Rowley sent an email just saying that he answered my questions, my general questions about the procedure of how White Bear does the invoicing. And he did not address any of the actual issues or the expenses that I had noted. He didn't address any of that at all. He just kind
I
of left it.
disagree, Director Brown. The email that Mr. Rowley sent you speaks for itself. And the reason why Mr. Rowley responded to you is because he's a shareholder in the firm. There's nothing really more I can say at this point in response to the allegations that you're making, other than I disagree with essentially all of them. And again, we're happy to discuss any of these items with you. You just need to contact us and tell us, the things that you have questions about. We are genuinely happy to discuss it with you.
Laurel, if I may.
Yeah.
Mr. Goodstein, I find your behavior absolutely unprofessional. You are very condescending to the director that sits on this board that pays your bill. And your bill is of public interest and should be discussed in a public meeting, since it's taxpayer money paying your bill. So there is no reason for Director Brown to have to wait till after a public meeting outside the public purview to discuss what you are charging a public entity.
Again, as I've explained, I don't know what items you're discussing right now. Like, I don't know what you're referring to. So it's in the best interest of the public to cover the matters that are on the agenda. This is something that, we would be happy to, address. And again, I'd be happy to put you in touch with the shareholder who looks at these billing items. I can't provide you with the answers you're looking for right now. That's why it makes more sense to just reach out to us with the questions that you have. My intention is not to be condescending. I'm trying to provide the most accurate response that I can.
Then I would recommend you take the smile off your face unless that's uncontrollable. Director Brown, if you would like me to send an email to them addressing your questions, when they send a response, we can make it part of public record at the next meeting.
Yes.
Yes, ma'am.
Make the fucking smile on us.
Is there any other comments that would like to be added to that?
No.
I do believe I'd like to make one. I think we need to really look over our legal fees. I mean, they're kind of getting out of control. I mean,
We were hit with a lawsuit by the town.
right,
We're gonna experience higher legal fees for the time being.
I know, but I get to that point where we got hit with that, but it's reoccurring when we have a budget for 12,000 and we're already at 44,000. It's concerning, very concerning to me as a board member too. So I think as a board, we should probably really look into this and do a little more research if the fees are appropriate, if they are appropriate to represent us and everything, because it's out of control. Our fees are 14,000 for this month alone is,
We've had several resolutions written up too. that
I
we have to
understand.
do. But yes,
but I do have a concern of it as well.
So we've got 4 or 5 committees floating around. Would you guys like to participate on one to look into this and go into line items and get more specific questions to address your concerns?
I don't think that's necessary because I already did that and I got no response. I got a email that just flat out answered my general questions and had nothing to do with any of the actual expenses that I highlighted. I wrote notes next to them saying these are this and how many people are working on this. And I got no response on that. And that's what I'm saying. And then basically in that email, it said, and everybody got that email that said, basically, you know, everything was fine and the attitude was, there's no room for discussion and that's it. So that's why I'm suggesting that, we may need to look into another legal counsel. Because this is, I mean, just in 6 months, this is escalating like unbelievable. I mean, if this was coming out of your own pocket, I think you would be questioning this. And it should be, because that's what we represent, the citizens of Kiowa. And so this is just. Every time I see an invoice, I just want to go, this isn't, can they really? Send us an invoice for this kind of stuff, and like I said, a lot of this stuff is being rehashed so many times, but with no results. So why should it be?
If you wouldn't mind giving us an example.
Well, one of them was the termination letter for town of Kiowa. First it was 90 days, then it was 10 days, now it's 90 days again. I mean, and then also that one is that adopting the digital accessibility policy. We don't need that. With town of Kiowa already provides that for us free. It's on the website, we get the benefit of it. They put that into place like in what, March?
Yes, but what they're doing is they're putting those in place for CRS.
I understand that, but that's down the road. We don't. I
I
mean,
would like to note a few. There were multiple ones in March pertaining to revising a new water well development agreement. Many discussions with you, your personal attorneys, regarding other agreements, a new chargeback agreement, a new water well development agreement that you're working on that hasn't been brought to the table and put in front of the public.
right.
There were many charges there. A lot of charges regarding your conflict of interest with your personal attorney. A lot of charges are pertaining to you, Mr. Kraft.
Pretty-
Set there or not, and direct them at, the town. You can say that all you want, but all of those invoices are open record for anybody sitting in this room and anybody that asks.
You are aware, I am a member of this board, ma'am.
What's your point?
So
That's my point. You're a member of that board
If-
and you're doing things that are absolutely. They're wrong and borderline criminal, Mr. Kraft,
you're out of line.
according to you, in your opinion.
Okay. I think we should move on.
Yeah, I think, we will table the profit loss reports to the next meeting.
Okay, so I have a
Can I
motion,
can make a motion?
so,
I make a motion. Okay, so table the profit and loss.
Somebody like to second it?
I'll second.
Okay. All in favor, say aye.
Hi,
Aye. All opposed, same sign. All right, we're gonna table that for the next meeting then.
Um,
Staff reports, I guess we'll.
Do you want
Paul's not here.
yeah. So, and he would have to speak to the violation at the well and
I can
his,
speak halfway to it. It's a constant thing.
okay,
When those SPRs go down, we're working off of one, which, skews the lab results.
do you need that?
So, no, I don't.
Okay.
I'm familiar with it.
Okay.
So until that other SBR is collected and we have continuous flow through there, it's gonna cause skewed, results. And Paul is aware of that. He stays in constant communication with them and myself. That is a form letter that is required of them to go out despite the communication. So they are aware of it and it's been rectified, so it should be corrected here.
Okay, so we didn't get fined.
No, ma'am. No, ma'am.
So-
And there's no requirement to send in a letter.
Okay.
The violation was fixed or the issue causing it was
Both.
fixed?
Both are fixed. I can't speak to the violation yet because that's based off the lab results. So once they get favorable lab results, those letters will quit going out, but they're aware of why they're not coming back favorable.
What was the cost to fix that?
I can't give you that off the top of my head.
Yeah, it'd be Paul.
Would you guys get back to us on that?
Sure.
And then was the board notified of that fix and that cost?
Pretty sure he did. I'd have to go back and look at minutes. Again, it's not something I could pull off the top of my head. I'm kind of like Mr. Goodstein. I'm not good on fly.
And I understand that we're in the process of terminating your contract, but can you please conduct yourself professionally in this meeting, ma'am?
I'm answering your question, Mr. Krause.
As far as the meter installations, I know that Paul is going to, there's like 106 meters, I think, left in town. So he's gonna need to order meters at some point, so he can get those last ones installed, because I don't think he's ordered them yet, but when we had our meeting the other day, the company that you used to order them from no longer carries the meters that are needed to work with the Neptune system. So, he was looking at other options. But he may have to order them from the Neptune company themselves, but he thought that the price was basically the same as the other meters. So he'll have to answer that one for sure, but that's kind of what he talked about when we had our meeting with him the other day.
So he's roughly gonna have to order at least 100 more.
106
100
ish,
more.
yeah,
And do those report on the same system that we have for the other meters?
yes. But that's the problem, is that the company we were purchasing previously is no longer carrying the Neptune meters. The meters they have won't read with the Neptune system. So, they're no longer carrying them for whatever reason.
I think Paul was just buying them in batches.
Yeah.
We didn't buy them all at once.
Yeah, and so,
That's why.
anyway, but he,
Now we need two systems.
no. It's just, that's why he's gonna order meters from a different company.
Okay.
Cause he needs to have the same one, so we don't have to order another system. But he thought if he buys them directly from Neptune, they're basically the same price as what we were buying from the other company. So he was gonna double check that, but, at our meeting we had the other day, so
Okay.
I can at least speak to that piece of it, where he's at with that.
Thank you.
All
So
right.
he can do that in more detail.
Can I?
Yep. no, that's-
I think it's for the wastewater treatment proposal. So Paul, I saw Paul's note. I know I'm kind of jumping out, but since it's pertaining to Paul.
Okay, oh, yes, okay. Yes, that is further down in your packet.
Yeah. I just got to use no.
Yeah.
Something.
Oh. So, yes.
This is system totals or something else?
This is
No.
from the fairground.
This is down in, new business. It's the first one in new business, so it's quite a ways into your packet. It looks like this, it'll say Elbert County Department of Health.
So we'll want to move to that now.
Well, I just wanted to see if Paul had anything to say in the meeting that he had about this.
I've attached the letter from Paul. We had him write him up. He thought that it was going to be okay. because they are not going to use so much that, like, he didn't even think we would get to like 50% of the tank with them doing this, cause they're not using, like 6,000 gallons a year.
I saw
So
that.
it was a very, to me, 6,000 gallons of sewer sounds like a lot, but in the grand scheme, it's not.
It's right.
Anyway, so they have requested to be able to get a tap for the sewer, so we could charge them for that.
Does he know what size? Has he got that far into it?
I don't think so.
Okay.
Just looking at his, yeah, he just said they would need to pay the tap fees based on the size of the sewer tap, hire professional, so. I think he would figure that out. I don't think they've quite gotten that far yet, but he kind of wanted, I think, approval first from you guys. And then he would go forward and kind of figure out what they needed, but, he did talk to them and he was okay with it, cause he said it was a pretty minimal amount.
Okay, we can put this back in and approve it as we get it.
Okay.
I just wanted to bring it up since it was called.
Okay,
Perfect.
yeah, I can put that back.
Moving on then. You had some.
One other thing on Pulse, I got a call from the lady who owns the bank building.
Farmers.
They've been
Yep.
having, can you guys expand on the issues going on there?
Basically, whatever's going on is their building itself. Paul has gone and scoped the sewer lines and everything around them. He brought in pictures. Our lines are clean and clear. So whatever's going on, it is not us. We haven't had any problems with the vet above them or the DMV below them. Which would be, if it's gonna domino, it's gonna domino. Or the fire department, nobody has, said anything except for them. Like I said, he did go in, he routed through the sewer lines, he dropped in cameras. Our lines are, well, as clean as you can get for a sewer line. So he said whatever's going on, it's somewhere under their building. He doesn't know if there's roots impeding it on their lines or, if there's a bend somewhere. I know that they've had plumbers up there quite a bit. At this, let's see, last week, the one gentleman came down and he said their bathrooms were working again. So whatever the plumbers did, got their bathrooms working again. So
This
it,
was last week.
yes, last week, they had bathrooms again. So as far as Paul has said, it's not us. It's them, it's their, something's going on with their building. I know that they admitted last month that they had flushed paper towels down the toilets. So that had kind of clogged up their system, cause you're not supposed to do that. Yeah, same problem we have with the jail and the elementary school. People flush the wrong things down the toilets.
Right.
But Paul said it's not our end. So whatever's going on, it's their building.
Would you all mind reaching back out to her and just bringing her up to date on what Pulse comments are for?
I believe we already did that, did we not? We've had multiple conversations with
I
them.
think we have, but I will ask Paul.
Thank you.
Okay. Okay,
All right.
okay,
Anything else? Moving on then,
okay.
just us.
Yep, so mine's pretty simple. I don't have much. You just have the May and June. Because RVS does not calculate in the bulk water, as part of its sales thing, its numbers are off. So even though it says we had a 28% water loss, we actually only had a 19% water loss because of the bulk water sales. And if you look at the chart, this is consistent with the last 2 Junes. So, for whatever reason, June, they seem to be about 19% every June. And I don't know if that's because it gets hotter and there's evaporation. I don't know, but so that's kind of where we're at. I mean, it's,
Do we have a quota on how much bulk water we sell? I know Burnco has been filling up quite regularly.
yes, well, we sold 440,000 gallons. So, and we have Burnco, we have the bank, we have, there's another one. I'm not gonna get their name right. We have another one though that's pulling some water.
I know Albert County. Then the.
Yep, Albert, yep, Roden Bridge pulls some. And then, like I said, there's one more. I can't think of their name. Pigeons, what's coming to head, but I know that's not right.
Okay, I just
Um,
didn't know if Burnco had like a quota. Cause I see them filling.
Yeah, they don't have a quota, but I do know, I was gonna give them a call because I know that pretty soon they're gonna get their cruncher thing up and going. And that will take a lot of water. And so I need to talk to them about that, where they may have to pull from somewhere else. So,
All right, yeah. Fine.
yeah,
Keep an
'cause-
eye on that.
yeah, and so I know that that's coming soon. And so I was gonna give them a holler and be like, hey,
I
so.
see them going all the time.
Yeah,
so I just wanna
so,
make sure.
yeah, so right now we have four groups that are pulling right now,
Okay,
so. Yep, and then we did, well, something I can talk about is, I've had a couple people call and want to fill up their swimming pool with bulk water, and we have told them no, cause they're trying to obviously outskirt their water. But so, and I checked with other people, the county won't do it, Elizabeth won't do it.
yeah.
So just so you know, people have been calling and I've been telling them no, so if someone
Thank you.
complains, I've been telling them no.
Thank you.
So, thought I'd throw that one out there, so you had an idea about that, so.
Perfect. Anything else on the system?
No,
reports?
like I said, mine was pretty simple this month, so we're just tootling along.
Perfect. I guess we'll move on to C, Kim.
Okay. Already discussed the asset that was found during the audit. The audit is not done yet. I'm still waiting for a draft of that. I think we'll have it next week. So as soon as I get it, I'll email it out to you guys.
When do we have to have that completed?
The end of this month.
Okay,
It's my
end of July.
understanding.
Yeah. Should be pretty close.
So, the other thing I had on here to talk about was USDA. I got a call from the USDA on June 13th. They were concerned and they were upset. It would seem a citizen that frequents your meetings makes constant public comment from Albert. She's from Albert, she's not a citizen here in Kiowa. Has spent months calling the USDA. Putting herself off as an assistant to myself out of this office, assisted me with completing our files. Asking questions about, whether the loan had been in arrears at any time. If it was, would they provide records of such to her? So the USDA decided to call me and ask if that was accurate or not. I have one particular loan rep that I talk with on a constant basis. It's Diana Edstrom. That frequents your meetings. That particular morning, she left a very snarky email or voicemail on that particular loan rep's phone. Demanding to know where those records were that she had been requesting for months. It seems she had made her rounds over the last several months with the PIO and the program director and a lot of the upper ups demanding these records. So I want you aware that that happened. They're aware of who she is now. But the ramification of that to your board is that it caused them to look at your loan a little closer. And when they did that, they realized you don't have a reserve account. That's been reported for several years. So through discussion with them, a long discussion with them, they've agreed to not pursue any sort of action for not having a reserve account put in place. They are pacified with the fact that the payments have been made on time for a long period of time. I personally don't know if they ever went into arrears because it's an automatic deduction.
I know.
So I don't know how they can ever be in arrears. And that's where we're at with it right now. I did talk to the auditor about the lack of a reserve account, and it was in his opinion, from many years back, with the previous president that, what you do have available to you in, the savings account and through assets would satisfy, I don't know, maybe a quarter of what that reserve account requirement is. They did confirm that that's not how that was written and that's not how it should be interpreted. The assets don't play anything into that, reserve account. It's absolutely cash on hand availability. And it's 120% of your current revenue. But like I said, despite the situation for what it was, and after a long conversation, they are pacified with the situation where we're at right now, and they're not pursuing that any further.
Thank you.
You're welcome. The other thing I wanted to talk about and put on record, since it was put on record at the previous meeting, I want some clarification on this for Sasha's sake. President Whitman asked at the last meeting directly to Sasha to address a discrepancy in his personal bill. That he advised he had allowed to go on multiple months, waiting for Sasha to correct it, find it and correct it. And he made the assertion at the meeting that if it's happening to him, it could be happening to other citizens in this town. And it concerns him that this office would be misbilling a lot of citizens and you would be missing out on a lot of revenue. So Sasha took the opportunity immediately the very next morning, she made it a priority to do research into that. And what she found was, his beginning month's balance in December was 107.96. He made a payment on December 18th for 110, which gave him a credit of $2.04 that carried over every single month. Because he continued to make the full monthly payment of what he felt the monthly payment is supposed to be. There was no discrepancies on this office or for Sasha's part and billing President Whitman. And this was relayed to the rest of the board. And because it was put on public record by President Whitman to Sasha, I wanted to make sure it was corrected on record. And I do feel that President Whitman owes Sasha a direct apology for the assertions that were made at the last meeting, which I'm sure we won't receive. So that's it. I just wanted that clarified on the record. Thank you, Sasha, for doing the legwork on that.
As far as the USDA, where do they stand with this individual that's not even part of the?
They're aware of who she is. Everybody in the USDA is aware of who she is now. The fact that she misrepresented a public office is a crime, but she's not a big enough fish for them to pursue.
Okay.
And she has been made aware that we know.
Go ahead.
Ready to take over?
Nope.
We're on public comments.
Cool.
Okay, well, I didn't have anybody sign up on the paper comments. So anybody in here? Okay, anybody online?
Yes, I would like to speak, Richard Croissant.
Okay.
On the billing, it's not a discrepancy in the billing. However, there is a discrepancy from the internet bill that I get. It says that you read the meters on 6/1 and 6/30, but the bill's due on 6/25. It's physically impossible. The paper one is correct because it says from the 15th to the 15th. But just
Yes.
on the internet, it says you read them on the 1st and the 30th, but it says it's due the same month on the 25th. So it's due 5 days before you read the meter. And that's on the internet.
Okay, I'll get that looked into and fixed.
Just look at you. Thank you.
I want to clarify if he's talking about express bill pay or the website. Town
The
website.
express bill pay.
Okay,
Yeah, I will look into that tomorrow, Richard, and get that fixed.
Thank you. Have a good
Mhm.
evening.
You too, sir.
Go ahead. Any other public comments? I'm assuming not. We'll move on to old business.
Okay.
Topic A, increase in water and sewer fees resolution final improvement. 24.7-1. Are we looking to do a vote on that? Is that-
No, it's been signed.
Okay.
Yeah,
So-
I didn't have a copy of it, and so I didn't know if it had been signed, so.
We just got that done, because legal counsel was out all last week.
All right, so it's signed. We're
Yeah.
good to go.
Yes.
Yes.
For your information.
Yes.
in the packet.
So that one's actually done.
Okay, moving on to B. School district portals 3-inch sewer tap. I believe that would be me. So. Teresa and I went and met with the school board and Mr. Cook up here. They had a lot of good research and everything from tap fees, from surrounding communities such as Callahan, Elizabeth, Peyton, Bennett, I mean, going through the list. They're looking to put in a 3-inch sewer tap fee for this preschool. Now, eventually, they're in hopes that the grant's gonna get passed through, and they're gonna get to move into their whole new school, and at that time, they'll vacate, go up to there, so. After reviewing it, we both looked through it and everything. I mean, we don't have a set fee for 3-inch, obviously, but we feel like they kind of got put in a rock in a hard spot with administration, with getting approval of their grant. So our recommendation is that we give them a break on that. We've also sent, so it was approved by our advisors, they didn't deny it any either, that we do a $13,000 sewer tap fee.
So it's 13,000 for the 1.5-inch water tap, and then 13,000 for the sewer tap. And which may be abandoned if they get the new school, if it's approved, which he made it explicit, and it needs to go in the meeting notes, that this is a one-off. This price will not be offered to anybody else. And the school superintendent acknowledged that with the new school, this price will not be what he will be offered. It will be determined at that time. Cause they were thinking, what is 6-inch?
Yeah, because they're looking that they're probably gonna have to go to a 6-inch correct, possibly for the
Yeah.
school. So we're gonna have to evaluate that
Yeah,
at the time.
Okay, so this is a one-time.
one-time deal,
Mhm.
nobody else.
Well, that's definitely gonna take a motion.
So
So, Scott, what sort of action do we need for this?
Well, one thing I wanted to bring up for the board's consideration is, as a governmental entity, generally, you are supposed to be treating people, equally for equal protection purposes. There are exceptions to that, like if there's a rational basis for doing this. But one thing that the board should at least put in consideration for this is that, the school district is a public entity. They provide public service to the community. Obviously, school districts are important. However, by doing this, arguably, it could be setting a precedent so that, there's a potential that other public entities might reach out to you, in the future for a similar discount. So that's something the board should keep in mind. I don't believe that you need to draft anything for this. It would just be something that you would vote on, but it would be important to include in the minutes the basis for the discount.
I can send you the blurb that I sent to them justifying how we came up with this.
Okay,
If you would like to put in the notes to really
yes,
nail it
please.
down.
Then I
will do that.
then I can put the exact language in for
And
that.
in comparison, from the reports that we found from other schools, that fee's quite substantially higher than most water districts for that tap fee.
You have to understand, they get to run their own,
Right.
they're not under
I
USDA.
understand that. But I also feel like, said, for the future, they're looking to build, and that's what we hope that they get a new school
Sure.
for this community. So that was my recommendation after doing it. So I'll let you take over, Eric.
Laurel, what do you think?
Oh, I agree.
You're comfortable with that?
Yeah.
All right. Well, let's go ahead and take a vote.
Okay, well, do we have a motion?
Okay, let's take a motion first.
I make a motion that the 1.5 tap fee of 13,000 plus the 3.5 sewer tap fee for 13,000 comes up to 26,000 for the schools to complete their modular project.
I'll second.
Okay,
All those in favor say aye.
I
All those opposed, same sign. Motion carried.
all right, cool.
Okay. Legislative memo over a view of the 2024 legislation affecting special districts. Resolution adopting digital accessibility policy. Scott, is there anything you'd like to add to this?
I don't think so. The board voted on the resolution adopting the digital accessibility policy at the previous meeting. Regarding the legislative memo, we sent that out for the packet at the previous meeting. If any of you have any questions about that memorandum, I'm happy to provide some answers. The one that I did want to make sure that I put on your radar is SB 24-233. This is a property tax revenue limit, and it limits specified property tax revenue for local government entities beginning with the 2025 property tax year. Based on my understanding of the bill, I do believe that the authority would be considered a local government entity within that statute. And what this limit is it's equal to the local government entity's base year qualified property tax revenue, increased by 5.5% for each year since the base year, including relevant property tax, or including the relevant property tax year. So it's because the authority likely would be considered a local government entity under that. You would just need to be aware that there's going to be a 5.5% limit on that.
That's only on AV values?
That's my understanding, and I would be happy to dive deeper into it and provide the board a memorandum regarding it and giving kind of more of the in the weeds kind of explanation. But I wanted to make sure that the board's at least aware of this.
Okay, I don't understand any of that.
So he's saying that there's a new cap on tax increases applied to assess values, which isn't the revenue driver for us here,
Okay.
although it may apply to, well, I guess it may have minor impact to us.
Okay,
Okay, well,
Especially seeing as we're trying to keep legal expenses low, maybe we don't need the memo, but we can just do some research as a board.
okay, and that was SB.
SB 24-233.
What was that again? SB?
Senate Bill 24
Yeah.
-233.
Mr. Goodstein, just a quick question. Because going back to the digital accessibility policy, since we kind of tripped off into a weed. The copy I have does not have a signature from your office. I'm not sure if that matters, because I assume this is not technically for the staff as it is now, but if I'm going to post it to the current website, I would need a signature.
We'd be happy to send you the signed version.
Okay, if you can do that, because then I can post it to the website for now.
Sure.
Okay.
So we don't need a,
No, it's already been,
okay.
I just need to have them sign it.
Sorry,
and post it.
We already did that, we're just waiting, and I sent a message yesterday
Yeah.
to the lady who sent it to us. For a
Yeah.
copy when we
Yeah.
got this.
Yes, so I just need to sign it. a finished signed copy.
Yeah, fully executed one.
Yes, that's the word.
Okay. Okay, next is reply to the town for termination of operation agreement.
And actually have D and E stapled together. Since I figured they kind of go together. Okay.
It's in the development directors.
Yes,
So here's D.
Yep.
And here's D.
yeah, I just stapled them together. So, yeah, it looks like that. Yep, yep. And I don't,
I have a question on that, the actual termination letter. Is that supposed to be signed by the town of Iowa or not?
Uh, Director Brown, the letter is from KWWA to the town of Kiowa, so they would have signed the letter.
No, but is town of Kiowa supposed to accept this as,
well, I assume you have to make a motion and second.
oh, I'm just asking, because I thought, well, in the last one, I thought it did have a.
Oh,
Exception,
This
signature, maybe
this
not.
one does not.
I know, that's what I'm saying. Just asking.
I'd be happy to provide an explanation about that.
Okay.
So at the previous meeting, we put together, or well, before the previous meeting, we put together a termination letter citing a particular provision of the operating agreement between the town of Kiowa and KWWA. That provision allows for a 10-day termination notice for the operating agreement, and it also has a 30-day cure period. Part of that provision requires that the letter include the defaults, the reasons for termination. Because of the nature of the defaults, our opinion is that the cure period wasn't really applicable to many of them because many of the defaults have been occurring over a period of multiple years. Having said that, we asked the town of Kiowa to acknowledge KWWA's preferred termination date. The town didn't acknowledge that date. So at that, as of now, the operating agreement between the town of Kiowa and KWWA is still running. So instead, we were directed to create this termination letter, which uses a different provision in that operating agreement, providing for a 90-day notice period. This particular provision doesn't require, any explanation of defaults or anything like that. So the reason why there was a line in the previous letter was we were asking the town to acknowledge the preferred termination date.
I also have another question too about, it seems this letter has gone back and forth. First we agreed at our meeting like 2 months ago that we were gonna use the 90 days with no default. Then all of a sudden it was changed to 10 days with 30-day cure period and then a whole bunch of defaults. Now all of a sudden it's back to 90 days with no default. Who has made these decisions? Because we didn't have an actual meeting where all 5 of us were here making the decisions about to change it back and forth or change at least to what it is now, which is the 90 days.
What was realized is that to try to come up with everything that they asked for was almost impossible.
I understand that, but who made the decision? Because it was done evidently through emails or something, because I was never aware of it. I was never asked, and we didn't have a meeting,
Right.
official meeting here to say all 5 of us are together making this decision to say, we're now gonna go with a 90-day termination and no default stated.
So that's what we're gonna determine tonight.
What do you mean we're gonna determine tonight?
Well,
Cause I'm just trying to figure out, we went with the 10
yeah.
and that got next, obviously, cause we didn't do it properly.
We did it
who's-
properly. What we found out is we had to do a lot of homework, which none of us have the time or the energy to do. So it was thought, okay, let's go back to the 90-day. Which we should have done in the first place. So that's what we're here to discuss right now.
Whose decision was it to go to the 10-day?
That was well,
Legal counsel?
yeah, well, actually, legal counsel, I think, wanted to stay with the 90-day. But we thought that we could do the 10-day with the 30-day pyramid. Their response was, you're gonna have to show us where we were defective. Realizing that doing that was gonna take a lot of man hours, or I should say person hours, which none of us have. We all have other priorities. So with that being said, we realize that that's not going to work. So now we're coming back. We're gonna either make a decision to either do something or nothing. It's entirely up to this board.
A lot of that communication was between our legal counsel and the town board's legal counsel. You guys were copied on the emails that went back and forth.
Well, that was my concern with the emails is that there's never been nothing clarified of default. And nobody has
No,
put anything on paper or in an email.
exactly,
That there were defaults that the town did.
yes.
Therefore, we're just saying, oh, well, we're just gonna go to 90 possibly. Because nobody can clarify any defaults.
No, it's not that.
I can provide an explanation, Director Wagner. Now, when KWWA sent the town of Kiowa its termination letter with the 10-day termination notice, the town's attorney responded requesting some specific information regarding the defaults. In the interest of saving on costs, it was decided that it just made more sense rather than trying to answer all those really specific questions to just utilize this 90-day provision instead.
Does that help?
Not really, to be honest, because there's no clarification of any defaults.
No, I guess not.
So there were defaults identified by both you and previous president. right, for
Yes,
the record.
absolutely.
Yes.
Yeah, but I don't have the time to sit down and start writing all that stuff down. Neither does the previous president or chairman.
So to say differently, defaults were identified and put on record. Once termination was delivered and the town chose to fight that termination, then it became either an issue of a larger legal battle or a simpler process, even if on a longer term.
Right, but the fact is that there were no specific dates attached to those defaults. Had to be identified because of the fact that there's been such a turnover in the town of Kiowa that you can't accuse Sasha and Kim of doing these defaults if there's not a time frame or a date attached to them that clarifies that it was their fault.
So that's part of the reason why there is a 90-day termination.
I understand that, but before, that was an issue that was being fought by White Bear about saying, well, we don't have those dates and we don't need them. Yes, you do. If you're gonna accuse somebody of doing something in that default, then you need to have specifics like dates. That makes a big difference here because of the turnover in this town of Kiowa management.
So whether or not the dates are needed, we'll let the attorneys argue that if the board wants to go through a default period or
I understand,
termination. for
but I'm
cause.
just saying that, if you're gonna, you were going by the actual operating agreement, those three different possibilities to cancel or terminate town of Kiowa as administrating KWWA. You still needed to follow a protocol with what the term said, and that was not done, and that's why I know now you're saying that you don't have those dates.
No.
They're probably, huh?
No.
So-
not that-
You don't have a date?
You do have the
Oh.
dates.
Well,
We
then they,
just don't have the manpower to put it
okay,
together.
but those dates, wouldn't they not apply to maybe Sasha and Kim? They were maybe dates back years before they ever worked here then? Huh?
Well,
I'm-
To clarify, Director Brown,
Okay, but I'm just saying then now you've changed your mind and saying now, or somebody's changed their mind. I wasn't involved in
Right.
that decision. So,
I don't think a decision's been made.
Yeah, I mean, really, we haven't made a decision. That's why we're
to
discussing
go
it now.
with what, the 90 days now?
If that's what we did vote on,
Oh, okay,
yes.
okay, all right.
Scott, go ahead.
I was just going to clarify, the operating agreements terms don't require in that 10-day termination provision to provide specific dates of default. It just says you have to provide the defaults. You have to explain why you want to terminate the agreement, and per the operating agreement, there is a 30-day cure period to allow the defaulting period or the defaulting party 30 days to cure these alleged defaults. Because a lot of these defaults have occurred over the course of multiple years, even if they've been brought to the town's attention, you know, through board meetings, for example, the notice requirements of the operating agreement are pretty specific. And, you know, long story short, KWWA asked the town to acknowledge its preferred termination date, knowing that a lot of these defaults wouldn't be possible to cure within the 30 days because they've occurred over multiple years. The town did not acknowledge that date, so at this point, for cost-saving purposes, this 90-day termination letter has been created, rather than going through the expenses of responding to their attorney's letter, which requested some very specific information.
That help. Laurel.
Not really.
Any questions? Anybody want to make a motion or not make a motion, or should we move on? All right, we'll move on.
One thing I would advise that the board take into consideration, the board approved in a previous board meeting an agreement with CRS to take over management responsibilities. Because the operating agreement with the town is still currently running, that's caused some complications in executing the agreement with CRS. It's also caused some complications regarding, like, for example, as a government entity, the authority needs to provide a website with some particular information on it, and it needs to be publicly accessible. At this point, the town has indicated that it's going to charge a fee for the authority to use its website. There's just been certain complications resulting from both approving, going with CRS, but still being in the current agreement.
For clarification, the town said they would quit absorbing the KWWA side and split the cost of what is being posted for KWWA to the KWWA, and the town would pay their portion. I believe the bill from January till June was 105.
I just signed it. It's the
Yes,
first one I've seen.
Yeah, so that's for 6 months. That's just posting agendas and everything that needed to go to your page.
So do we need a motion for this?
Yes, we do.
I'm sorry, where are we now?
The 90-day.
Okay. Do we need to take action on D? Or,
We just discussed all that.
okay,
Not that I know of.
So we have a motion. Go with the 90 day.
I make a motion to go with the 90-day termination letter.
Second.
We do have this. Does anybody have any questions? Yeah, Brett?
Yeah.
Okay, let's do a roll call vote, please.
Okay, Director Brown,
No,
Director Parker,
Yes,
Director Wager,
No,
Director Kraft,
Yes.
President Whitman.
Yes.
Okay, 3-2, it passes. Okay.
Okay.
Next is the Elbert County sewer thing that we already talked about just a little bit.
Paul was not able to attend,
Okay,
so we asked Sasha and him to go send because they made a meeting. I did not make that meeting. Oh, this is what it was on.
So to catch you up, basically the Elbert County, the fairgrounds would like to be able to access, utilize the sewer plant. They're looking at only 6,000 gallons a year, which, is my understanding is not very much. And attached to their request, I'll talk to them and he is comfortable with them doing that. Based on your recommendation, then he will figure out what size tap they will need.
Okay.
And then we would, figure out the charges and everything. So
so is that gonna be a 12-month? Or 12 months out of the year?
It's only
I think, oops.
3 to 4 months out of the year that they use. it
Yeah, they-
Over at the
is it
fairground.
just for the RV hookups?
I believe that's
Or they hook us up?
Uh-huh.
I mean, they have people up there almost 12 months out of the year.
do they really?
Yes. So, you know, I don't see why we don't charge them just like we do everybody else. Every month.
Are they requesting water or just sewer?
Just sewer.
Well, they are already tapped into water,
Right.
So they're just.
so now they want to tap into
Right.
to the sewer. I don't see any reason why we should only just charge them for 4 months, charge them
Yeah.
for 12 months.
Well, and that's easy. I just make it up as another bill payer or
Right.
whatever, so.
So. I don't know, you know. Regardless of how much they do or don't put in there, they should pay just like everybody else.
That's up to you guys.
What do you guys think? I mean, it's a lot easier math. than it is to try to figure out, well, they only used it 4 months, which 4 months did they don't use it for? So,
So I should make a motion that they should be charged 12 months like everybody else for their sewer. Since they're already hooked into water.
Yeah, do we have to do anything with Paul before we go towards this?
probably just his recommendation. You know, as far as, what things,
What size of it?
what size of tap.
And stuff.
Yeah, so that's what he would figure out once he had direction from the board.
and should you be talking to the, Elbert County, Health Department to find out if they actually have people there all year round, or how many people they may have, so that it would justify what you're asking to do it for 12 months and a year? I mean, I think there should be a little further discussion, like you said, with Paul, and then maybe with, the, Elbert County Health Department, just to clarify a few of these questions.
Yeah, is the county in a hurry on this? Can we?
I don't know.
I don't get the sense that they are in like a emergency rush. It's just something that they wanted to broach and see if it was a possibility.
So maybe we table until the next meeting.
We can, yeah,
Right, I think
but it
so.
sounds like we have more questions.
Okay,
Laura, would you write down your questions so that we can get those to Paul, please?
Well, mainly just, okay, that's fine.
If you would,
and
I mean, they're,
you can get those to me and I can.
Okay.
do we need a motion to table this, or we still have questions?
If you do, so moved.
Okay,
I second it.
All those in favor to table this? Say
Aye.
Same sign, opposed? The motion passed. Okay. Water and sewer policy resolution, I just saw that
that's this one. Yep,
right here.
Yep. And this
what-
is one that you've looked at before.
Right,
It's just really finalizing it
okay.
as a resolution.
Resolution 2024 dash what?
I think it is, let's see, you've got two others, so I think this is number 5.
5.
Uh-huh.
Okay. Where's the town, or where's Kiowa Water and Wastewater Authority is a body corporate and a political subdivision of the state of Colorado, and whereas pursuant to 32-1-903 CRS provides the board of directors of the authority with the management, control, and supervision of all business and affairs of the district, and whereas the board has determined it to be in the best interest of the authority and health, safety, and welfare of the residents within and without the boundaries of this it is service area to adopt a policy regarding division of work expense and attached hereunto as exhibit A. Now therefore, be it resolved by the board as follows. The board hereby approves the policy regarding the division of work and expense attached to hereunto as exhibit A, adopted this. So, which goes into everything about the sewer. So, anybody have any questions?
I have a couple questions.
Yes.
I'm sorry.
I have to change the date on this to July.
Oh, yes,
Okay,
yes,
the date
yes,
should be July.
yeah, because sorry, it was after it was a.
Yeah.
Nice.
But.
And then the resolution at the top, what number is that gonna be?
Number 5.
Number 5, okay, that needs to be put in there.
Yep.
And then also down there in the second paragraph where it talks about the supervision of the business affairs of the district. We're not a district, it's an authority. So that word district needs to be taken out, put authority in there,
Good catch.
Where are we gonna,
right here,
oh, got it, yeah, sorry,
okay, yeah.
got it,
Because they are using forms and they don't always change it to authority,
got it. That in fix.
okay, and then July.
Anything else?
No.
Okay. Brett?
Nope.
Tim? I would entertain a motion.
So moved.
Okay. Do I have a second?
I'll second it.
Okay, it's been moved and seconded. All those in favor say aye.
Aye.
All opposed, same sign. Motion passed.
Okay.
Okay. Public records request policy. You got this one?
That should look like that.
That. Nope,
Nope,
next one.
should say Kiowa Water and Wastewater Authority Public Records Request Policy.
Yes, I got it.
Got it, okay.
All right. Scott, would you give us a quick review on this
Sure.
public records request policy, please?
Yeah, no problem. Essentially, it's a policy that the authority would use regarding core requests. If the authority doesn't have a policy put in place for that, it's not actually able to charge fees to respond to these requests. So we recommend that the board adapt this policy so it has a policy put in place when it receives core requests. And CORA being the Colorado Open Records Act.
And again, this is when the copy I have doesn't have any signatures. So I will, once it's approved, if it's approved, I'll have to have signatures for that.
I didn't think we got to it last month.
No, we didn't get to it, and so I'm just saying, so
Okay. I would entertain a motion to accept this.
So moved.
I have a second.
I second it.
Okay, all those in favor say aye.
Aye.
For a piece of paper I'm supposed to sign.
not yet, don't sign that one yet.
What about the date? Does that need to be adjusted?
We'll adjust it.
Yeah,
Okay, so it's be July 9th or whatever,
yes,
okay.
yeah,
All right.
that'll have to be, I don't have that one, so.
Do you need my copy or no?
No, I don't need your copy, I have a copy, so I'm just,
All right.
yep,
Certification of insurance, copy of KWWA last asset audit and declaration page.
And since the audit isn't quite done, we don't have that
I
yet.
don't have that.
Yeah,
Okay.
so,
So we table this?
yes.
Okay, let's table that.
So do I have a motion?
Take a motion to table this, certification of insurance.
I make a motion to table certification of insurance.
Do I have a second?
I'll say.
Okay, all those in favor say aye.
Aye.
All opposed, same sign. All right, engagement letter for litigation attorney. Scott, would you explain to us why we had to have a litigation attorney?
Sure. Essentially, the authority is currently in a lawsuit with the town of Kiowa. My firm does not perform litigation, so if the authority would like legal counsel during this litigation, it needs to engage an attorney who has expertise in litigation. And my understanding is that Mr. Hollers has offered to fulfill that role.
He has. With much urging from Scott. Because at first I had no idea why we needed another attorney and why, and then Scott said, well, it's you have to do. So not really wanting to do it, I made some phone calls and Jacob Hollers was the one that answered me back. He does charge $500 an hour. And so I hope he's as good as his money. So I guess what I need is a motion to accept.
I have some questions first before. we
Yes,
go any
absolutely.
further this, okay. As president of the KWWA, I feel it's your duty and responsibility to keep all the board members informed as to any and all issues concerning KWWA. But it appears that certain issues and discussions concerning important issues are being made by some of the board members without the knowledge of all the board members and outside of official meetings, which again is a violation of the rules of the conduct of KWA meetings. Due to the multiple emails back and forth between you and certain board members, George Rowley, Scott Goodstein, and other unknown attorneys, there appears to be some serious issues involving KWWA on some of the board members have not been informed of. Okay, my first question is, and now you've talked about this, but my question is, has a lawsuit or complaint been filed against KWWA? If so, when was it filed? Who filed it and why wasn't a copy provided to all the board members?
I was served
Okay,
as president of the KWWA.
okay,
All right. I had to be coached by Scott and I was coming up on the 21-day deadline
okay.
that I needed to get a lawyer to represent KWWA. I did as I was told to do.
But why wasn't all the board members advised that this existed? I still have not been officially advised that we have a lawsuit out here until this came up.
Because I was the one that was served.
But
But is that not towards the whole
that's the board,
Or is
isn't
it
it?
just to you?
Well, I don't know. That's a good question. Scott, can you answer that?
The lawsuit is with KWWA. It's not with the president of KWWA. To the best of my knowledge, I believe that, we did tell the board about this. I can go back and look through my emails in the event that this wasn't sent to every board member, or, at least the complaint. I apologize for that. That was inadvertent. But to the best of my knowledge, we have made sure that KWWA was aware that this lawsuit was filed against it.
no, I disagree.
I do too, because I haven't been informed of it at
No.
all.
And the first time I even knew that something was going on was this email from George to Eric on June 21st. It says, Eric, I think it's time to hire litigation counsel for our office to step back. I'm going, step back from what? What is going on? And like I said, as of even today, I never knew until we saw these packets that there was actually a lawsuit out there and it affects all of the board members. That's what I'm concerned about.
I'm sorry,
What's a lawsuit regarding?
Yeah,
Scott, what is it regarding?
My understanding is that the town of Kiowa has filed a law, well, I would have to look through the complaint for specific language, but it's regarding a board member's qualifications.
So the lawsuit's an injunction to undo votes that we took the day before we terminated them the last time. As part of that, they're challenging my seat on the board as they have done twice before, and Scott and George have weighed in on past. As far as what's happened with Spencer Fain, that's really been President Whitman, who's been discussing with legal counsel to get guidance on the best path of action. And if you wouldn't mind taking it from there, they advised you.
They advised me to get legal counsel to litigate this. I'm not sure exactly what the authority is going to litigate. Not even sure why I was served. Basically, it's a town questioning Tim's.
My understanding is that the lawsuit is against KWWA as an entity, and that's why you were served as a representative of that entity. You know, I would have to look at the complaint to know the specific language at this moment.
so is it possible to get a copy of that? Like I said, I would like to have.
It's certainly it's certain, yeah, I'd be happy to provide you a copy, and in the event that we haven't already done that, that was
we haven't.
an oversight. If we did.
You didn't, but I had no clue about this at all until I got that email and George is saying, we need to get a litigation, you need to hire someone, and they can't do it. Well, what are we litigating? That was my whole question. I mean, I didn't know that
To
at
be
the
honest
time.
with you, I don't know.
Okay, all right,
Until-
but I would
yeah.
like to see a copy of the lawsuit. That should have been provided right off the bat to all of us, because it concerns all of us
Well,
as board members.
okay. What is your next question?
Okay, that. Just a minute, it's kind of all run together. Again, we're not getting decisions made with all of the board members, we weren't even, aware of it. Now, on this letter, this engagement letter, I have a question about it, because it says it's to, Kiowa Water and Wastewater Authority. And then when you get over to the second page, and it says July, but July 8th, it should be July 9th. Anyway, and then you get to the second page, it still says June 8th, and then whatever that is. And then it says accepted by Tim Kraft.
Yeah, I don't
What-
understand that.
Tim, did you sign an engagement letter with Spencer Fain too?
I have not.
Okay, then why would they have your name in there and all that?
I think because.
It's possible that Tim's name is in there because KWWA is one of the named parties in this lawsuit as of right now, and Tim Kraft is the other named party. It's possible that Mr. Hollers just committed a scrivener's error. I don't believe that Mr. Kraft has, actually been in contact with him, or at least to the best of my knowledge, I don't believe that.
Okay, because that the letter that was in our packet that we got on July 3rd. It actually, on the front of the letter, it did say, "Dear Tim,"
Yes.
instead of "Dear Eric." So it looks to me like it was a form letter or this engagement letter was something to do with Tim Kraft. And then when they just copied it over and forgot to change all of the pertinent information on there for KWWA. So that's why I'm questioning this. And I asked you, Tim, you said, no, you have not. You have not have an engagement letter with Spencer Fain. Is that correct?
Not on this issue. We've worked with Spencer Fain in the past, but I have not talked to them in the last few months.
So you have not engaged them for anything relevant to this lawsuit?
I have not.
Okay,
Anything else?
all right.
Okay,
Want to get on record?
so we need, I need a motion to accept this. Legal counsel,
I'll make a motion to accept a litigation attorney for our lawsuit.
Second.
all those in favor say aye.
I,
I have one other question, Ken.
Yes,
I'm sorry.
absolutely.
I'm sorry. What, if we engage Spencer Fain to do our litigation, does that mean we're still using White Bear also for all the other things too? And that means we've got two attorneys going with, and according to the agreement, the engagement agreement, they're doing, first of all, they're charging $550 an hour. Okay. Plus, this agreement is very much like the White Bear one, which is very open-ended, very generic. It's not tailored to KWWA and our specific needs. So I'm concerned that we're going to have two attorneys, two legal counsels that are going to be billing us open-ended billing. And we're gonna not be able to control any of this again, and we're gonna have double the
Scott,
invoices.
can you explain this?
I mean, I can't really speak to Spencer Fain's billing practices because that's not my law firm. Our firm would still perform its duties as outside general counsel. We just don't perform litigation.
Basically, we hired Jacob Hollers, that's our litigator. For whatever happens, I don't know, I have not seen a court date. I have no idea what they are going to litigate, when it's gonna be litigated. He'll have to inform us on that.
So how do we know when we actually, since there's questions about when this is going to start, how do we know when they're going to start? They're not gonna just keep billing us for a certain amount every month that we're not really using them, or they're just kind of standing by.
If we don't contact them, they can't bill us,
All right, but why are we then voting on this tonight?
because we need a litigator. to
So-
litigate.
I can answer Director Brown's question regarding why this is being voted on tonight. Per the complaint, KWWA has to respond to it within 21 days. However, an attorney, and the board needs to vote to engage an attorney before an attorney can perform that work. My understanding is that Mr. Hollers has been in correspondence with the town's attorney, who agreed to give KWWA an extension to allow for enough time for the board to vote on it, so that Mr. Hollers could then be engaged and then can answer the complaint.
So we
he's
need to
already-
hire,
So he's already talked to the board or the town?
Yes,
sound lawyer,
the town lawyer,
He's already talked to
yes,
them.
yes.
so we got an extension.
so I guess I'm confused about that, how he could be representing us when we haven't signed an agreement with him.
Not technically,
He's not. So Mr. Hollers does not represent KWWA until you vote to approve his engagement. However, there wouldn't be enough time for the board to have an attorney, to actually answer the complaint within the initial deadline. So Mr. Hollers, from what I understand, reached out to the town's attorney and discussed having an extension, so that way KWWA has adequate time to respond to that complaint. That's my understanding.
Okay.
I haven't spoken to Mr. Hollers myself. This is just my understanding based off of some email correspondence that I've been CC'd on.
So what is the deadline to respond right now? What's the date?
It's already passed.
I-
That deadline's already passed, has it not, Scott?
Let me check my email correspondence. I believe that
I
Eric.
think on the
on-
2nd or 3rd of July. And therefore, Mr. Holler's.
My understanding, based off of the email that I'm CC'd on from Mr. Whitman, is that because of the 21-day extension that the town's council agreed upon, the new deadline to respond is July 23rd.
23rd. That's if we don't hire Jacob Hollers.
Well, I'm not comfortable speaking on behalf of Mr. Hollers. I'm just trying to explain in general, the court processes regarding responding to complaints.
Don't know if that helps or not, because in a lot of ways. It
Muddies the
doesn't help
water.
me either.
Yeah, I don't know. I'm just concerned about more legal fees that we can't afford. And I know we have to get a litigator to help us with this because we've got a lawsuit, but it just. I'm just concerned,
I am too,
I am too.
but I don't know of any other way to do it.
right? But I just wanna know the ramifications of either signing this or don't signing it or whatever's going on, so that's.
Well, then we start the process all over and we have until July 23rd, you told me?
Well, I haven't told you anything, but my understanding is that Mr. Hollers told you in his email to you that the deadline that the town's council agreed upon is July 23rd.
Yeah. All right, so we have a motion and a second, is that correct?
Yes, correct.
All right, why don't we just do a roll call vote, please?
Okay. Director Brown,
No,
okay. Director Parker,
Yes,
Director Wager,
I'm gonna say yes, but I think we monitor that closely. with our
Absolutely.
bills. We need to do that. I mean, we need litigation,
Yeah, I don't, from what I've been told, we don't have any choice.
but we need to monitor it.
That's why
Very
we're praying.
closely,
I
instead
did
of
call, he asked if we want him to be on Zoom and I said no.
Right, we need to monitor
Right.
and just make it
Absolutely,
brief.
Director Kraft,
Yes.
and President Whitman.
yes,
Okay, 4-1, it passes.
all right. Any correspondence or discussion? No? I would entertain a motion to adjourn the meeting.
So moved.
I'll second it.
All those in favor say aye.
Aye.
All opposed, same sign. All right, this meeting
7:27.
is adjourned. I think.